My name is Cesar Pereira. I'm the chair of the CIR Brazil branch, and it's my honor, my privilege to welcome you all to our program here at the São Paulo Arbitration Week. It's interesting that the Brazil branch was created in 2019, and it was launched precisely during the São Paulo Arbitration Week 2 years ago. So the São Paulo Arbitration Week, in a way, is sort of anniversary celebration also for the Brazil CIR branch. And we are very happy this year to have here with us a group of fellows and chartered arbitrators and scholars and practitioners that represent, in a way, a lot of what the Brazil branch has been doing for these past 2 years. We, as well, the whole world has been doing. We have we have also taken advantage, in a way, of technology to be able to build relationships and bridges all over the world, taking our using really the platform that CIR offers to connect with the other 40 branches in the world that gather the nearly 20,000 members that CIR has nowadays. We have here with us tonight Anne Ryan Robertson, who is the president of CIR, and has been instrumental in the creation of the Brazil branch. And actually, she was, in fact, in attendance and was a speaker in Brazil during the launch of the branch 2 years ago. And so it's wonderful to have her back with us. And we hope we can have her back in person as soon as possible here in Brazil. And we also have a lineup of speakers that cover from the Americas, the North America branch, New York branch, Canada branch, the branches with which we have been partnering in a number of occasions and events, but also from other countries in South America, with which the Brazil branch has been developing an intense agenda of events and joint initiatives, so that we can have an ever greater presence of CIR in South America. We also here have with us fellows from the UK, fellows from Portugal, who are always together with us in our initiatives, and also fellows from Africa and from the Middle East, with whom we have been able to connect now during the pandemic, and with whom we are partnering also in events during the Dubai Arbitration Week that will take place next month. We have here with us our fellow Ricardo Apriliano, who will speak about Brazil, one of our most distinguished fellows in Brazil, and Sherlyn Tung, who will be speaking from Hong Kong, and who, in addition to her many accomplishments, will certainly become a fellow of CIR in the near future. And I see that we have now Dorothy from Nigeria with us. It's a pleasure to have you again here. Dorothy was part of the group of tutors that ran the fellowship program that Brazil offered earlier this month. And so it's a pleasure to have you again here with us. So without
thank you, Cesar. Hi, everyone.
Hi. And so
Hello.
without taking any more of our speakers' time and thanking all of them, especially those who are in very inconvenient time zones to be speaking at this time here at the São Paulo Arbitration Week. It's an immense honor I can't thank you enough for your generosity in agreeing to speak at this hour. I thank you all for your attendance, and I would like to turn the floor now to our keynote speaker, N. Ryan Robertson, who is a partner at Lord in Houston, an internationally acclaimed arbitrator, and as I have already mentioned, president of CIR International in 2021. So, Anne, thank you again, and the floor is yours.
Thank you very much for the kind introduction, and thank you to the organizers for inviting me to speak to you. I welcome all of you who have joined us today. It's always a pleasure to visit Brazil, even if today's visit is in fact virtual. Overarching today's panel discussion is the question of ethics, both that of the arbitrator and counsel. Standards of professional ethics form the backdrop for everything lawyers do, and ethics continues to be a difficult question in the international arbitration realm. Not because counsel and arbitrators are unethical, but because the ethical constraints on arbitrators and counsel differ from jurisdiction to jurisdiction. And because of those differences, one party may be placed at a disadvantage. So I would first like to explore with you some of those differences. And the first one I would like to focus on is communications with an adverse party. Many national codes or rules of professional conduct provide that a lawyer may not communicate directly with an adverse party, that the lawyer knows to be represented by counsel without the permission of counsel or absent extraordinary circumstances. But let's change the question a bit. Let's suppose that the adverse party is a corporation. May you communicate with that corporation's employees despite the fact the corporation is represented by counsel? In the US, the answer is a resounding no. Under the UK rules, this conduct is apparently permitted. A US lawyer representing a party in an international arbitration may feel ethically constrained not to communicate with the employees of the adverse corporation. The lawyer for the adverse corporation may feel no such constraint. So, one party has been placed at a disadvantage. And what about witness preparation? Under the US rules, it is common practice to rehearse proposed lines of direct or cross-examination in detail. The only restriction being that the witness's testimony is not improperly influenced. We even have a term for this practice, woodshedding. Under the UK rules, this cannot be done. And while there are certain exceptions in the civil law countries with regard to arbitration, civil law systems permit little, if any, contact with witnesses prior to trial. And of course, this is the outgrowth of the fact that in the civil law system, the inquisitorial method as opposed to the adversarial method is used. Again, one person has been placed at a disadvantage. Now, the IBA rules on the taking of evidence have attempted to address this disparity, and Article 4.3 provides that it's not improper for a party, its officers, employees, legal advisors, or other representatives to interview its witnesses or potential witnesses to discuss the prospective testimony with them. But the IBA law rules are soft law, only binding if the parties agree to be bound. And it might be appropriate at this juncture to raise the recent report of the ICC entitled The Accuracy of Fact Witness Memory in International Arbitration, which concludes that witness testimony can be inadvertently influenced. The report provides measures that can be taken to reduce distorting influences and their effects. So let's turn to the issue of adverse Legal authority. Does a lawyer have an obligation to bring pertinent adverse legal authority to the attention of the tribunal if opposing counsel fails to do so? In common law jurisdictions, such as the United States and Canada, the lawyer's duty extends to the tribunal. So the answer is yes. In the civil law world, the answer would typically be no. And then there is the problematic area of document disclosure. The Redfern Schedule and the IBA rules on the taking of evidence have bridged the gap between the US's any and all documents approach to the more restrictive identify with specificity. But what is the lawyer's professional obligation in terms of ensuring that documents required to be disclosed have been diligently searched for and in fact produced? Not surprisingly, the civil law codes typically do not address the issue. In contrast, US lawyers must make a reasonable inquiry and certify that disclosure is complete and correct. Once again, one party potentially has been placed at a disadvantage. We've explored some of the uncommon ground as it relates to counsel, so now let's turn to arbitrators. The cornerstone of arbitration is the independence and impartiality of the arbitrator, which raises the issue of arbitrator interviews. Are they appropriate, or is impartiality and independence compromised or destroyed if interviews are conducted? The Chartered Institute has a very helpful guideline on interviewing prospective arbitrators designed to guide the parties and the arbitrator regarding what is appropriate conduct. But it is worth noting that not all arbitrators will consent to be interviewed, and this position does not fall along common law and civil law traditions, as you might presume. I have a personal example for you. I had identified 3 potential arbitrators, all from the same London chambers. I sent each of them an email asking for an interview. I got back 3 responses. The first was, I will not consent to an interview. My CV is on the website. The second one was, send me the questions and I will answer them in writing. And the third, well, what time would you like to talk? I'm available on the following days and times. And then there is the corollary question of how deep should an arbitrator's disclosures go? The failure to disclose is at the heart of many vacatur motions. And I'm sure many of you have read vacatur decisions and thought, I would not have decided that issue in that manner. In the United States, deep disclosures are expected, and indeed, if you are selected to serve as an ICDR arbitrator, the ICDR has a checklist of potential relationships to be disclosed and concludes with, are there any other relationships that might lead to justifiable doubts about your independence and impartiality? I was recently nominated by a party that was a member of a multinational conglomerate. Our firm represented 2 other companies in the conglomerate in entirely different product lines. In addition, my firm has offices throughout the US, and this representation was being done by another office. I told the party that was nominating me that I was going to have to make a disclosure. The counsel did not want me to do so, but I said it will be disclosed. And I disclosed that relationship, and indeed I was challenged, but the arbitral institution denied the challenge. Had I withheld that information, there would have been a challenge after the award if the information was uncovered. And as an arbitrator, I want to avoid my name ever appearing in a vacatur case. The IBA guidelines on conflicts of interest provide the well-known red, orange, green list for disclosures, but this is simply soft law. I know in the US, when a party cites the IBA guidelines as support for failure to disclose, the courts almost uniformly state that however laudable the IBA guidelines may be, they are not the standard for the court. And that standard, like in many countries, remains in the eye of the beholder, and that eye can be influenced by many factors. A case that demonstrates rather forcibly that even members of the judiciary do not necessarily see eye to eye on the question of what must be disclosed in terms of independence and impartiality is the case of Positive Software versus New Century, which is out of the Fifth Circuit. New Century, upon not prevailing in the arbitration, undertook an investigation and uncovered that 7 years before, the arbitrator and a number of lawyers from his firm and counsel for New Century had represented the same party in a number of lawsuits. Although the arbitrator and counsel's name appeared on the pleadings, neither the arbitrator nor the counsel had ever attended or participated in any meetings, telephone calls, hearings, depositions, or trials together. They were 2 of 34 lawyers working on the case from 7 law firms. The cases spanned from 1990 to 1996. The arbitration was in 2003. New Century filed a motion to vacate, which the trial court granted, saying the relationship should have been disclosed. On appeal, the appellate court affirmed, at which point Positive Software filed a petition for rehearing en banc. The petition for rehearing en banc was granted, and the Fifth Circuit reversed, holding that the relationship was trivial and trivial relationships need not be disclosed. Of course, what is trivial remains in the eye of the beholder. So the question becomes, should there be an overarching ethical body for international arbitration? That very question was posed to the audience at the recent Legal Business International Arbitration Summit in London. 60% of the participants said no. So where does that leave us? It is at this point that I would like to turn to the role that the Chartered Institute plays in ensuring the highest ethical standards. I've already mentioned the guidelines for interviewing prospective arbitrators and how they can provide clarity to the process. In addition, each member of the Institute is bound by a code of professional and ethical conduct, as well as the provisions of the Chartered Institute's charter and bylaws. To enforce the professional conduct of its members, the Chartered Institute has a professional conduct committee that is independent and not subject to the control of the Board of Management. The Professional Conduct Committee is required to have at least one member who is a former or sitting judge. Currently, it has 2 former judges. It also has members from the Chartered Institute, as well as lay members. Their purpose is to investigate any allegation of misconduct and take appropriate action. Now, this misconduct can include, but is not limited to, conduct which is injurious to the name of the Institute, conduct that renders a person unfit to be a member of the Institute, or conduct that is likely to bring the Institute in disrepute. It also includes a significant breach of professional or ethical conduct, and also failing to significantly perform below the standards expected of a competent practitioner or professional person acting in the field of private dispute resolution. So what is the procedure? Anyone can lodge a complaint against a member. The Professional Conduct Committee then decides whether the claim is to be referred to the disciplinary tribunal, or whether the complaint should be dismissed, and/or whether the accused member should undergo supervision or retraining or receive other assistance from the Institute in order to improve the member's work, competence, and conduct. If the complaint is to go to the disciplinary tribunal to hear and determine the charge, then full due process is afforded, and the party against whom a complaint is made may be represented by a lawyer. In the event that the disciplinary tribunal finds that the charge is proven, it may decide to impose no sanction, or it may impose one of the following sanctions: a reprimand or warning, may suspend the member from membership of the Institute for a period not exceeding 12 months. It can withdraw the chartered arbitrator status without limit on time, and it can, and this is the most onerous, expel the member from the Institute. Since 2009, twice a member has been expelled. The first involved an instance in which a member represented, or I should say misrepresented, to another member the status of a retainer account. The second, well, that arbitrator had taken much, much too long to issue the award. And these results, the expulsion of the members, can and are published on the Chartered Institute website. And thus, when the public sees the Chartered Institute post-nominals, they know not only that this person is properly trained in the intricacies of international arbitration, but that person is bound by and ascribes to the highest professional ethics. And the power of the post-nominals cannot be overstated. Allow me to share with you a personal experience. A number of years ago, I received a fax, unsolicited. The fax was from a country that is known for scams. I threw the fax in the mail, and then upon reflection realized that the person that had signed this letter requesting representation in the courts of Texas was a Chartered Institute member, a fellow. So I responded based on the fact that there were post-nominals. And as it turns out, that particular case was a case of first impression in the state of Texas and was perhaps one of the most exciting and lucrative cases that I've ever been involved in. As we will undoubtedly learn from today's panel, ethics continues to be a thorny problem in international arbitration, for which there are no clear-cut standards. But what is known is that members of the Chartered Institute are provided with guiding principles and held to exacting ethical standards. And it is for these reasons that arbitral institutions look upon favor having Chartered Institute members on their panel of neutrals. I thank you for the opportunity to address you, and I look forward to hearing the panel discussions.
Thank you, Anne. It is always refreshing to hear that the Chartered Institute can and does play an important role in ensuring ethical standards, especially in the context in which ethical issues are very much the subject of discussion. So thank you so much for your keynote speech. And I will now turn to my colleague, Andrea Galhardo Palma, who is a fellow of the Chartered Institute in the Brazil branch. And she is a sitting judge. She is the only judge, a judge in active duty that we have in our branch, which is a reason for great pride, in our parts. And so Andrea and Tonico Monteiro da Silva, who's also a fellow and a practitioner and an arbitrator based in Brazil, they lead one of our subgroups within the Brazil branch that deals specifically with what we call arbitration in court, with the relationship between arbitration and courts. And we benefit a great deal from having Andrea and Tonico leading that group because of their different backgrounds, especially. And the purpose of this discussion here today is to bring to all of you some of the discussions that they have been conducting in that group over the past few months. So I will now turn to Andrea, who will be the moderator for the first part of this event, and wish you all a great discussion today. Thank you, Andrea. The floor is yours.
Thank you, Cesar. Good evening, everyone. It's a pleasure and honor to be here to moderate this really international event with highly qualified FCIRB speakers who will give us an overview of how arbitration works in their country, covering hot topics such as arbitrator ethics, challenges, and vacatur. I'd like to say thank you first to Anne for what you have been done for CIARP and for being a role model to many FCIARP women around the world, inspiring and empowering all of us. And this is very important. Diversity is not only number, but really real opportunity to hear our voice. And I'd like to say thank you also to Cesar for give us, me and Tonico, this spotlight and to share our thoughts with our colleagues around the world. So I won't take any time from our speakers. I just want to say that all speakers will have 10 minutes in 2 sessions. I will moderate the first session, and each session will give you, I will give me and Tonico one question just to stimulate our discussion. I will start with Professor Paula Costa from Portugal. And I will start with the first question in outset, Professor Paula, because I know you have, you can't stay any longer after your presentation. And so how does your jurisdiction deal with clear violation of substantive public policy? And is it a reason for annulment? Please, Professor, you have this floor again.
Thank you, Andrea, for this question. But please allow me, before addressing it, to thank the invitation to the CIARP for having me here, in the persons of our president, Anne Ryan Robertson, and Cesar Pereira, the chair of the Brazilian branch. And I'm very pleased to be here. I'm honored to be here, because you give me the opportunity to participate in an important discussion that has, from my perspective, indeed gained increasing relevance in recent times. I would like to greet all my colleagues on this panel and the moderators, you, Andrea, and Tonico, who helped us to organize this debate. I will try to give you an overview of the Portuguese system, how we deal with the problems we are facing today. I think the overriding topics of this session are 3: arbitrators' ethics, challenges, and vacatur. The first idea that came to my mind has to do with what I would identify as a timeline in the problems arbitration faces and has been facing. I believe that if a few years ago one could say that arbitration lived the due process of law paranoia, nowadays our attention has shifted to the scrutiny regarding arbitrators' qualities, conduct, and relationships. In one word, arbitrators' ethics. And now one aspect that I believe we must consider in our equation in an attempt to answer the question that was addressed to me. What is the connection between the violation of ethical standards by the arbitrator and the potential annulment of the award on the grounds of violation of public policy? I suppose that we cannot directly link the violation of ethical parameters to that cause for annulment. This is because the latter, as happens, for example, in my system, in Portuguese law, is only present when the content of the award violates the international public policy of the Portuguese state. In fact, and from the Portuguese stands, the conduct of the arbitrator may have violated all the standards required. But this does not necessarily mean that the content of the award contravenes the public policy of the Portuguese legal system. So the question that must be raised is, why do we resort to public policy as a cause for annulment when there is a violation of ethical parameters by the arbitrator? From my perspective, because arbitration laws do not typically provide, as they are based on the model law, for causes of nullification of the award grounded on reproachable conduct of the arbitrator. If we think about the consequences of ethical parameter violation by the judge, we typically find solutions in our civil procedural systems. And these solutions typically lead also to the annulment of the decision through means of challenge that even allow overruling res judicata. The analogy seems obvious to me. In procedural systems, we do not ask about the goodness of the decision rendered, because the violation of ethical parameters by the judge constitutes an intolerable offense to the rule of law. Even if the decision is good, could be considered good, the system does not allow us to accept it because the guarantees concerning the decision maker have been violated. The same will be said about the violation of ethical parameters by the arbitrator. And here lies, from my perspective, the analogy. The decision, good or bad, cannot be tolerated as an act capable of producing legal effects. The violation of ethical parameters is a violation of the concept of jurisdiction in itself. It is not, therefore, the violation of public policy by the content of the award that determines the eventual destruction of this award. It is a procedural public policy that imposes, commands this consequence. The guarantees of the decision maker are, from my perspective, jus cogens. If we accept these premises, I believe we will have grounds to state that the violation of the guarantees of the decision maker in arbitral proceedings provides grounds for the annulment of the award, because it undermines those same guarantees. If we start from these premises, it remains for me to say that the Portuguese legal system provides for the violation of substantive public policy as ground for annulment of a decision. If the decision, the award, violates the international substantive public policy of the Portuguese state, it can be challenged. I believe, however, that the arbitrator's violation of ethical parameters comes under another set of values, those relating to the guarantees of the decision maker and of the jurisdiction. They cannot cease to be valid in arbitration because they are essential to the concept of jurisdiction in a state governed by the rule of law. Additionally to these causes of annulment, Portuguese law foresees as an autonomous cause of annulment the breach of principles of due process of law. If I were to give you a general overview on the control of the ethical standards of the arbitrator, Portuguese law follows a double path. In case of an ad hoc arbitration, its control is done by the state courts. In institutionalized arbitrations, the control lies with the institution itself. But the criteria that determine the inadmissibility of serving as an arbitrator are identical, whether assessed by the application of strict law, statute, or by the application of soft law. There is no difference at all. The ground that triggers the censure of the arbitrator is the lack of impartiality or independence in the eyes of the parties. But this clause is being concretized by the state courts in the most objective manner possible. For this reason, it is very common for state courts to resort, for example, here in Portugal, to the IBA guidelines in an attempt to free the evaluation of an arbitrator's impartiality and independence from absolute subjectivity. As you all know, Portugal does not have very impressive numbers of arbitrations. We are just 10 million. So it consequently does not have very significant numbers regarding challenges on the grounds of violation of ethical parameters by the arbitrator, by the decision maker. But I think the known cases allow us to state that challenges to arbitrators are very rare in Portugal, and that the typical grounds for such challenges are usually more or less remote relationships between the arbitrator and the party. A look at state court case law also leads to the conclusion that in general, courts reject arbitrator challenges, and to my knowledge, they have not, to this date, set aside any award on the grounds of breach of public policy due to a violation of the decision maker's guarantees. This said, unfortunately, and as I believe is the case in other jurisdictions, in Portugal, uncertainty about impartiality and independence of arbitrators is also created after the award is rendered, or when its content is, to some extent, expected by the parties. The party who loses, or who expects to lose, and who cannot ask for a merit check of the award, seeks the annulment of this award on the grounds of violation of ethical parameters by the decision maker. And here I think state courts will have a very relevant role to play. While it is true, from my perspective again, that the lack of impartiality affects the core of the decision maker's guarantees, it is also clear to me that if contrary to good faith, the party's conduct cannot have the intended effects. Like all and every legal situation, the exercise of a right, the right to challenge, is also subject to the general clause of good faith. I believe that the only way for us to mitigate the risks that conducts damaging to good faith itself entail is to give relevance to the way in which the arbitrator has behaved throughout the proceedings. This means that when state courts are faced with allegations of lack of impartiality, there should be a distinction between the cases where a party raises the grounds for refusal of the arbitrator at a very early stage of the proceedings, and those where the party waits for its outcome to begin, or allegedly begin, a detailed investigation into the relations of the arbitrator that can lead to the annulment of the award. The improper exercise of the right to challenge the decision on the ground of lack of impartiality or independence of the arbitrator is as wrongful as the exercise of judicial function by an arbitrator who is not impartial. But as I said before, most of the challenges to arbitral awards here in Portugal are not based on the breach of ethical principles by the decision maker. We don't have an intensive case law on this problem. If we accept the distinction I drew at the outset between substantive public policy and procedural public policy, or jus cogens, we may find some cases where the violation of substantive public policy is claimed to have bearing, namely when the arbitral tribunal awards punitive damages to the party which Portuguese indemnity or tort law does not accept or allow. But the most frequently invoked ground for annulment in Portugal, although usually without success, is still nowadays the violation of fundamental procedural principles. Thank you, Andrea, for your question. I hope I have been able to give you an answer that allow an understanding of the coordinates in which the link between violation of ethical standards by the arbitrator and consistency of the award is set in Portuguese law. Thank you again for having me here.
Thank you, Professor Paula. Very interesting approach and well done. And I will turn to Frederico. Feel free, Frederico, if you want to make any comments regarding what Professor Paula said. But for you, I have a special question regarding hot topic, material fact of challenge. So the question is the mere omission of a material fact as such cause to challenge an arbitration proceeding or the award? Or does your jurisdiction require more? Feel free, you have the floor. Thank you.
Thank you very much, Andrea. Good evening to everyone, and thanks for the Chartered Institute for the invitation for me to speak. I am, despite being Brazilian, I'm practicing in England. And so when I speak about this topic, I think it'll be helpful perhaps for the viewers if I can make a comparison, because on this particular topic, we've had the benefit of having the coincidence of two cases, one in England and one in Brazil, which happen to address the same issues. So the issues of conflicts of interest, as well as an arbitrator's duty to disclose, have been hot topics in recent times, as you say, and specifically recently, because in England we've had the Halliburton decision, which some of you may well be familiar with. And in Brazil, there's been a recent decision from the São Paulo tribunal, known as the Fazon case, which is astonishingly similar in the issues respective, which each court was asked to decide. So if I start first with the Halliburton case, which was decided by the English Supreme Court. So on the 12th and 13th of November, the Supreme Court heard, 2019 this was, heard oral submissions from the parties from the Court of Appeal in the Halliburton case. Representing Halliburton was Lord Grabiner, and he submitted the issue for the court to decide as follows. Does the English law require a party to submit its disputes to an arbitrator who has breached his duties to that party and whose conduct has generated the legitimate concerns generated by the Court of Appeal? So Halliburton argued that the Court of Appeal had got it wrong. It advanced the same arguments as certain interveners. Those interveners were the Chartered Institute of Arbitrators, the LCIA, and the ICC, along with its own. And I should mention that the LMAA and GAFTA, which are two arbitral institutions that deal with shipping law primarily and commodities laws, were also interveners, but they were for the appeal being dismissed. So you have the ICC, the Chartered Institute, and the LCIA on one side, and the LMAA and GAFTA on the other. All of them highly respected institutions, but with slightly different views on the issue. So their position was firmly grounded on the Court of Appeal's judgment in the first issue. On the first issue, Halliburton argued Chubb had an advantage in being able to have a dress rehearsal on matters before the arbitrator in the transocean arbitration, gaining inside knowledge, and would be privy to ex parte communication. It argued this was specifically prohibited in the agreement between parties, and it also argued the failure to disclose prevented Halliburton from objecting to the appointment or taking measures to prevent any prejudice in their arbitration. So Chubb argued that Bermuda form insurance, like maritime arbitration, was a specialist sector where there was a limited pool of competent arbitrators, and it was common for multiple appointments with common parties and arbitrators to take place. There was no objection by Halliburton to the arbitrator's involvement in the earlier arbitration, where he was the sole arbitrator, which he disclosed. Chubb also argued that the Court of Appeal had applied a two-stage test with regards to disclosure, and that this required determination of, first, whether disclosure was necessary in all the circumstances, and second, what the significance of the non-disclosure was in the context, giving rise to justifiable doubts. It argued that this approach was correct. On the 27th of November 2020, the Supreme Court handed down its judgment. The Supreme Court was made up of Ladies Arden, Black, and Lords Reed, Black, and Hodge. The latter is the one who gave the leading judgment, Lord Hodge. So Halliburton's case was summarized as being put in terms of apparent unconscious bias. The court set out 5 reasons justifying the formation of that perception. First, the benefit received by the arbitrator in the form of remuneration, so his payment, his fee. 2, an unfair advantage gained by Chubb being able to influence the arbitrator through their arguments. 3, Chubb's ability to communicate with the arbitrator and know his responses. 4, the arbitrator's failure to disclose, thereby excluding Halliburton's ability to form a view and mitigate any unfairness. And finally, the 5th, the arbitrator's failure to pay proper regard to Halliburton's interest in the fairness of the procedure. So these are the grounds advanced by Halliburton. Lord Hodge expressed the view that it was only the 5th point, which made by Lord Grabiner, which had some force. So that's really where they concentrated. So he set out the law. He stated that under English law, there is no distinction between neutrality and partiality, and that this is becoming an accepted feature internationally. In terms of the test for disclosure, he makes a distinction between the institutional and IBA guidelines, which is a subjective test, i.e. in the eyes of the parties, and the English law objective test, i.e. in the eyes of the fair-minded, informed observer. He recognizes that the Court of Appeal developed the law by holding there was a positive duty to disclose. So until the Halliburton case, it was unclear whether there was a positive duty to disclose. I'll come to the Brazilian position in a moment when I discuss the Fazon case, but that's an important development. And he described that such a duty operates as an implied term in the contract between the arbitrator and the parties, much like under English law, the duty of confidentiality, which has been previously established. So it's a common law duty. Lord Hodge also stated that the obligation to disclose arises from Section 33 of the English Arbitration Act, and that's the mandatory duties of the arbitrator, which they cannot derogate from. And it involves a duty of fairness, and it goes on to set out his ratio on the positive duty to disclose. He then discusses the interplay between the duty to disclose and the obligation to hold information confidential. So we all know that arbitrations tend to be confidential, and I just mentioned that under English law, this is an implied term of the contract between the arbitrators and the parties. So Lord Hodge held that where an arbitrator is appointed in multiple arbitrations with a common party, such appointments must be disclosed as a matter of English law. Any duty should include A, the identity of the common party, B, who and how the arbitrator was nominated, C, confirm whether the appointment is related to a common event, so where there are matters that may be similar. He explained that there is a public interest in this duty, which is consistent with the arbitrator's duties of fairness and impartiality. Whether they arise from Section 33 or relate to the court's powers of removal of an arbitrator under Section 24 of the English Act, however it arises, the arbitrator's duty to disclose is more onerous than a judge's. So that's an important distinction as well. However, parties are able to dispense with or limit such an obligation by agreement. But in the absence of any such dispensation, Lady Arden specifically emphasized the obligatory nature of disclosure. Now, coming to your original question, Andrea, about the failure. So what the Supreme Court held in Halliburton was that a failure to make such a disclosure may amount to apparent bias. Whether it does or not will depend on the relevant custom or practice. And this is the way that they neatly were able to deal with the LMAA and GAFTA on the one hand, the ICC, the LCIA, and the CIARB, because they are different types of arbitration and the very nature of shipping arbitration in particular, and that distinction from normal commercial arbitration. So any assessment, they decided, of a failure is based on the time upon which the duty should have been complied with. In other words, before the appointment. When the arbitrator is considering the appointment, that's when he ought to think whether or not to disclose. And that's the time period when, if you're making an assessment as to whether or not they should have disclosed, that's the period of time that you're considering. However, that's different from apparent bias, which is assessed on the information available when that reaches court, so after the event. So that's the English position. On the 11th of August 2020, the São Paulo Appeals Court set aside an arbitral award on the grounds of lack of impartiality of the arbitrator, further to Article 21(2) of the Brazilian Arbitration Act, also of 1996. In this Fazon case, one arbitrator acted as chair in the first arbitration and was appointed by one of the parties in the second arbitration, with one common party and overlapping subject matter. As in Halliburton, the arbitrator disclosed its previous appointment as chair in the second arbitration, but didn't do so in the subsequent arbitration appointment to the other party in the first arbitration. So when he was appointed in the second arbitration, he disclosed that he was already, but he didn't go back and disclose again. Exactly the same circumstances as the Halliburton case. So just to give some context and the distinctions, that in Brazil, arbitration is quite a specialist practice, as all the fellows in Brazil will know. And generally, there is a small pool of available arbitrators. Renowned arbitrators are rumored to engage in many, many arbitrations at any time. And their position, therefore, bears more resemblance with the positions that were argued on behalf of the LMAA and GAFTA, rather than the LCIA and the ICC. So the São Paulo courts held that all the information of a personal or professional nature capable of giving rise to justifiable doubts as to the impartiality or integrity of an arbitrator must be immediately disclosed. So like the Supreme Court, the São Paulo court held that the duty to disclose, codified in Article 14(1) of the Brazilian Arbitration Act, is triggered upon nomination when considering the appointment and is a continuing duty. So therein lies the big difference between the English and the Brazilian position, is that until the Halliburton case, there was no law, there was no obligation on the arbitrator to disclose, unlike in Brazil, where you have it codified under 14(1). So the São Paulo court held that any omission should not be regarded as normal or usual and amounts to a failure, which goes directly to the perception of partiality alleged, and therefore directly affects the validity of the award. So São Paulo court relied on a previous case known as Abengoa, as a binding precedent and concluded that the lack of disclosure further to Article 14.1 of the Brazilian Act was in of itself sufficient to give rise to justifiable doubts of impartiality. Having made that finding, the São Paulo court didn't proceed to consider whether the facts in that case amounted to apparent bias. So just touching on those, you can see the differences between the two approaches when they are exactly the same issues that the court has to decide. I probably eaten into my time, so I'll stop there. Thank you.
Thank you, Frederico. If I remember well, I think the Supreme Court of London point out 3 objective criteria to identify this duty of disclose. If I remember, it's very thoughtful, because in Brazil we don't have such objective criteria, and I didn't remember exactly the name of this criteria, but I remember the court pointed out the objective criteria. I think it's very helpful, this kind of the criteria, because the courts can rule the case or hold the case a little bit more straight, you know. But thank you for this comparison. I think it's very important to have this perspective. But you are right. The courts in Brazil are very how can I say, tough regarding the duty of disclose, because we have a mandatory law. And so to follow our discussion, I will encourage Dorothy from Africa to speak. And thank you for being with us and to share your thoughts from Africa. And I will encourage you to answer this question regarding ethical standards. What are the arbitration ethical standards applied in your country? National law, soft law, institutional rules? Please, you have the floor.
Thank you very much. It gives me great pleasure to be here today. And I want to thank Anne for her leadership and mentorship at the Chartered Institute of Arbitrators. I also want to thank Cesar for inviting me. This is the second time I'm speaking in this Brazil intervention. To answer the question that Andrea has put to me, the rules are virtually the same as the list that Anne has given to us. And that is basically because most Nigerian arbitrators have been trained by the Chartered Institute UK, and I'm one of them. So everything Anne has said resonates and applies in Nigeria. The law that regulates the conduct of arbitration and arbitrators in Nigeria is the Arbitration and Conciliation Act. Since mostly lawyers are arbitrators in Nigeria, they are subject to the rules of discipline of lawyers, particularly when lawyers are acting as arbitrators. They come under the same rules that would affect any arbitrator in any jurisdiction. Because recently, as you would agree, there have been an upsurge of international arbitration in Africa and in Nigeria. So the rules that govern the conduct of arbitrators all over the world are applicable in Nigeria. And if I take the parameters that Anne mentioned, you talk about communication with the adverse party. You cannot communicate with the adverse party. If that is found out, that will lead to a challenge and the courts will uphold that. And when you talk about interviewing of witnesses, the same rules apply. And we also apply the IBA rules of taking evidence. And one of the critical rules in arbitration is your impartiality and independence. And that applies all through the arbitration process. That then brings us to the interview of prospective arbitrators. And my position as an African who specializes in arbitration is that I would never attend any interview as a prospective arbitrator. My answer would be, my CV is there. You can Google me, and if you think I have the relevant qualifications, then you appoint me. So I have, prior to the commencement or the setting up of the panel, I definitely do not interfere or interact with any party that is proposing to appoint me. So the issue is you appoint or you don't appoint. Then when you come to disclosure, there are checklists. There must be disclosure under the soft and hard law. The Supreme Court of Nigeria, as one of the biggest, commonest grounds for a challenge of arbitrators in Nigeria is misconduct. And the Supreme Court of Nigeria listed, in the case of Taylor Woodrow, the conduct of arbitrators that would amount to misconduct, which will warrant the setting aside of the award. And in that case, the Supreme Court expanded the meaning of misconduct to cater for parties' interests. The grounds upon which the court may constitute misconduct include delegating arbitral duties, unfairness, accepting hospitality or bribe, acquiring an interest in the subject matter of the dispute, arbitrator acting in excess of his jurisdiction, examining a witness or obtaining information in the absence of the other party, and dining or accepting hospitality. With regards to, and this is provided for in Section 48 of the Arbitration and Conciliation Act. And Section 48 of the Nigerian Arbitration Act mirrors the Article 5 of the New York Convention, which provides the grounds for setting aside of arbitration awards. We also apply, particularly in international arbitrations, we apply the IBA guidelines for conflict of interest, the red book, the orange book, the green book. But one of the most crucial points to note in arbitration in Nigeria is the duty to disclose, which is continuous until the end of the arbitration where you deliver an award. And arbitrators in Nigeria are very careful because on the grounds of lack of disclosure, that award is gone. I was a typical case that the court set aside the award, the Nigerian court set aside the award for lack of disclosure. Was an ICC case in which I was a member of the tribunal. It was an oil and gas case. and the presiding arbitrator had provided legal opinion in another matter for one of the parties and for the group of the respondents, but failed to disclose this. And at the end of the day, the loser went on the website of this IOC and saw that the presiding arbitrator had provided legal services in the form of writing an opinion on another matter for one of the parties and had failed to disclose this during the arbitration. And the Lagos High Court, on grounds of non-disclosure, set aside the award, which was very unfortunate because it was a huge oil and gas arbitration, and it would put the parties at great expense to start another arbitration. But the name of the presiding arbitrator was published everywhere. It was so embarrassing. And as Anne had said, this is not where any international arbitrator wants to be, whether in international case or in an ad hoc arbitration. So the rules are basically the same. And also in that case, the counsel representing the party against whom the set-aside application was brought tried to make a distinction between the red book, the green book, and the yellow book. And the court said, non-disclosure is non-disclosure, whether it's under the red book or the orange book or green book. Once there is a disclosable event, the arbitrator runs a risk of non-disclosure. And if the arbitrator that has misconducted himself or herself is a lawyer, then additionally, in our jurisdiction, that arbitrator faces the disciplinary committee of the Nigerian Bar Association. So sitting as an arbitrator in Nigeria is not a tea party, because Nigerian parties are very quick to rush to court to apply to set aside the award. This does not mean that Nigerian courts are not arbitration friendly. Nigerian courts are definitely arbitration friendly. Our courts support arbitration. They enforce the arbitration agreement. They enforce the arbitration award. But when there is a breach of due process or a violation of public policy, which is part of the arbitral conduct for conducting an arbitration, you can be rest assured that if there is proof of such misconduct or such non-disclosure, the award will be set aside. And I've never had any award being set aside. So you have to be very, very careful. Sometimes there is an issue between too much disclosure and non-disclosure. The general policy is, if you are in doubt, you disclose. And once you've disclosed, then you save yourself any embarrassment. If you disclose and there's a challenge, you go away, another appointment will come. So it's strictly the same rules that apply. And Nigerian arbitrators, having been trained by the Chartered Institute, majority of them having been trained by the Chartered Institute of Arbitrators, recognize these rules and would abide by these rules. Thank you very much.
Thank you, Dorothy. It seems that the Nigeria court has this similar approach with São Paulo State Court. We are arbitration friendly also. We have been set aside a few cases since Brazilian Arbitration Act was enacted. But regarding duty to disclosure, we had a case, important case, that court decide in a way, in a hard way, but it's in a few cases. I think the crucial ground, the duty of disclosure, is very important to fix. Maybe with a objective criteria. I know it's very difficult to achieve this objective criteria, but I agree with you. If you have doubt, disclose, because you have to focus on to protect an enforceable award and to protect the arbitral proceeding to the end. And I agree with you. Thank you for your thoughts. And I will turn to Faris, the last but not least. And I'm very curious about how arbitration works how does arbitration works in your country? And I will address to you this question: what is the most common ground to set aside an arbitration award in your country? Is your floor.
Thank you, Andrea. And before I begin, let me just echo the comments of my predecessors in thanking you, Andrea, and the Chartered Institute, and for hosting us and for hosting this stimulating discussion, and to Cesar and the Brazilian branch. And as a member of the UAE, the committee of the UAE branch, it would be remiss of me not to just remind everyone of Dubai Arbitration Week, which is also taking place in mid-November, and allow me to extend an invite to anyone and everyone who would like to attend, either in person or virtually. Now, before sort of looking at the UAE and at Dubai arbitration, I think it's interesting what Dorothy was saying in pointing out the prevalence of practicing lawyers as arbitrators, and I think one has to wonder and consider whether that has any impact on how we look at the standard for arbitrators, and whether that should be different when looking at arbitrators who are practicing lawyers who will have different sorts of relationships with parties and as clients or otherwise, than arbitrators who are perhaps engineers, architects, or from another profession, whether it should be looked at differently in the same way that as Federico highlighted, and as was considered in the Chubb decision, arbitrators are looked at differently in certain specialist industry arbitrations, such as maritime arbitration and the LMAA rules and those sorts of things. So I think there's many topical issues that definitely haven't been solved by the arbitration community and will be considered in great detail moving forward. In dealing with the UAE specifically, I think it's important to frame the position here and also your question in the proper context. So the UAE is a jurisdiction that is in the midst of some flux, one could say, in a good way. We've had the new federal UAE arbitration law, which came into effect in 2018, and that was really a big step forward. It's based on the model law. It's a very progressive, arbitration-friendly law. And in answering your question, I think traditionally challenges to awards have been have taken the form of procedural challenges and challenges to due process. So before the new arbitration law, for example, the arbitral procedure was dealt with under the Civil Procedures Act or the Civil Procedures Code here in the UAE, which required for example, the rules of evidence to be observed in arbitrations, and that applied to things like taking oath for witnesses. So, if a witness did not take the oath and the tribunal relied on that witness's evidence, that could be a grounds for the award to be set aside. It also applied to things like, the arbitrator needing to be present in the place of arbitration when he's signing the award for that award to be valid. These are things which obviously are not really part of modern international arbitration, and that's been rectified in the new law. So those sorts of objections, while parties still seek to rely on them because that's what has worked in the past, they're no longer observed by the courts. There's a very instructive decision of the Court of Cassation from last year. The Court of Cassation is the highest court here in the Dubai jurisdiction, and in that case, the party seeking to set aside an award relied. This is relevant to the topics that we're discussing today, but they relied on the fact that one of the tribunal members was not suitably qualified to decide the dispute because of certain financial crimes investigations against him, and they also relied on the fact that another tribunal member was impartial because of the way that they were appointed. And the way that the court dealt with this application is quite instructive. They rejected the application on a couple of grounds. Firstly, they made the point that under the new law, the general principle is that an arbitrator is impartial and independent following acceptance of their appointment. So that's essentially a sort of an assumption from the outset, which really moves the burden, if you will, of trying to prove that an arbitrator is impartial, and makes it far more difficult. And secondly, they also applied quite strictly the Article 25 of the new law in relation to waiver. So they said that the objection had not been brought in a timely fashion, and therefore the objecting party had actually waived their right to object, and therefore they rejected the application. And on that last point, I wonder whether, if I understood Dorothy correctly, for example, she mentioned in the case that she raised that the party seeking to set aside the award, the losing party, had actually gone and carried out research after receiving an unfavorable decision and found out that the arbitrator had given this opinion previously, and then they had used that to have the award set aside. So based on this Court of Cassation decision, that would not work here in the UAE, because by waiting that long to actually do the research, that research, assuming that was already available to them once the arbitrator was appointed, they failed to effectively make the objection in a timely manner, and therefore they would not be able to rely on those circumstances. So in that way, the new law has really brought the arbitration regime in the UAE forward to a great degree. It's much more difficult to raise objections. The criteria for seeking to set aside an award is now based, primarily, it mirrors very closely the language of the model law and of the New York Convention, and all of that, is a good thing. And there's just one other development, I think, which also puts this all in context. So here in Dubai, which is probably where the majority of arbitrations happen in the UAE, there was recently a decree issued by the government, decree number 34, and this has only happened in the last month. So it's really fresh. But essentially the three arbitration institutes in Dubai will be amalgamated into one, the Dubai International Arbitration Center, and the default seat of arbitration for that center will be moved from sort of onshore Dubai to the DIFC, which is a free zone within Dubai, and that free zone is a common law jurisdiction based broadly on the English system, and it's considered to be very arbitration friendly, very sophisticated, experienced jurisdiction. So from my point of view, that signifies an even greater shift towards a real progressive and arbitration friendly framework here in Dubai and in the UAE. And of course, if anyone is interested in the new decree, that will be a very hot topic at Dubai Arbitration Week. So so make sure to tune in and you'll hear all about it. So I'm conscious of the time, and I'm reluctant to take any more time. But of course, if anyone has questions, I'm happy to take them or either online or offline. So thank you, Andrea.
Thank you, Faris. I think the arbitration world is very small. It's because I think we are bound by the same standards, I think ethical standards, and also grounds to vacate and challenges. And maybe because, probably because our countries have adopted the ancestral model law and the New York Convention. It seems to me that this word is more than I think. So I don't know if you have much questions, but I'm just concerned about the second session, and I would prefer close this first session, and I'd like to say thank you to all of you, Professor Paula, Frederico, Dorothy, and Faris, for save your time for this session in multiple time zone. And I will finish my job here, but I'll be here. And I will ask Tonico to moderate the second session. Please, Tonico, you have the floor.
Okay, thank you, Andrea. Can we now turn to Shirlington? And Shirling, I understand you have a very international background. You're a Chinese American lawyer based in Hong Kong. So the question I would have for you, and I know we have sent you some previous questions, but in order to make things more exciting, we've changed everything. So we will improvise and put you on the spot. I guess the question I would ask you is, do you think there's much change in ethical standards from your experience in America and in Hong Kong? And how would a violation to an ethical rule be a cause for vacatur or to set aside an award? Would that be possible in Hong Kong?
No, for fear of having any political wrath, but because I am quite proud of my background. You were very close. I am indeed very international, but I am Taiwanese American. I know it's a huge deal right now. Normally I would just kind of sweep it aside, but I'm starting to wonder whether or not I'm going to be able to maintain this Taiwanese passport for much longer. But thank you for the question. It is indeed nice to have something thrown at me, but if I am a bit unprepared in the response, it's because I completely prepared with the questions. What I will say though, based on the ethical standards, and Anne may correct me or I may get again in trouble, which is very common, so I'm okay with that. But I have found that ethical standards in Hong Kong seem to be a bit, I wouldn't say that they're higher, but they're a lot more, they're observed a lot more from my colleagues here in Hong Kong or from my experience in Hong Kong. As we all know, every profession, in particular the legal profession, we are all held to a certain standard. Oh no, Stephen's also from the US. Stephen may call me out on this later. But we are all held to a certain level of standards.
I think you will. I think you will.
I know.
And we'll welcome that, Stephen.
But we are held to a certain standard of professional guidelines. And, you know, we do, I would say the lawyers generally all adhere to it, at least the majority of the time, in particular for international arbitration. But I have recognized, unfortunately, when with my time here in Hong Kong, I often get the jokes, you know, everyone watches Suits, everyone watched Ally McBeal, depending on what time you were, and they said, look at all of the lawyers, you know, your ethical standards are kind of shady. You don't necessarily, you always know how to kind of swing by them. Whereas here in Hong Kong, the Hong Kong Law Society has quite a tight grip. over the Hong Kong legal community. And it's not just the Hong Kong qualified practitioners for barristers or solicitors, but they also have quite a tight grip over registered foreign lawyers, which is what we fall under. So in Hong Kong, under the Hong Kong Arbitration Ordinance, there is no ethical standard requirement that arbitrators are held to. Arbitrators under the Hong Kong Arbitration Ordinance are required to be independent and impartial, which is in line with most of the major institutional rules. But the Hong Kong Law Society has a Law Society Code of Conduct that all Hong Kong qualified lawyers, solicitors, barristers, as well as registered foreign lawyers are required to adhere to, or they are subject to review or trial by the Hong Kong Law Society. So I would say that I see the idea of an ethical violation or standards to be much higher and much more of a concern to practitioners here in Hong Kong.
Fantastic. And just if it cannot just go back to one of the questions, do you know what is the most common ground for setting aside awards in Hong Kong from what you've seen so far?
Definitely not a violation of any public policy is very rare in Hong Kong. One thing I do want to reiterate, because I know that there have been a number of concerns that have been raised in the world in relation to whether or not Hong Kong is still a stable place to resolve commercial disputes. I will say that in the recent case laws that we've seen in cases in relation to enforcement or setting aside of awards, Hong Kong remains very pro-arbitration. So the Hong Kong Arbitration Ordinance was revamped. When I say recent, it's now been a decade. 1st of June 2011 is when it was entered into force, and basically it's based on the model law. And so the most common reasons for trying to set aside an award is the reasons that are set out under the UNCITRAL rules. It's nothing different from, I think it's always the same thing. Is there a major procedural defect? Have the parties' due process been violated, etc.? It's very rare that you see a public policy argument raised. And when we take it one step further, the only reason that an award can be set aside for a tribunal misconduct or ethical violation would be under the public policy prong. And from what we've seen since the arbitration ordinance has passed in 2011, there has not been one award that has been set aside for such a violation. I will point out, though, prior to the revision in 2011, the Hong Kong Arbitration Ordinance had a specific provision, Article 25, that allowed a party to challenge an award for an arbitrator misconduct. Now, that provision was deleted with the Arbitration Ordinance of 2011. So we really haven't seen any successful setting aside applications for ethical violations.
Fantastic. And if I may, just a final very quick question. Do you think there is is it fair to say that lawyers tend to challenge our arbitration awards when their clients lose as a rule, just to get it sort of a second bite at the apple, or this is not something that you see very often in Asia?
It depends on your client. My clients, the ones that aren't successful, they always want a reason to challenge an award. But here in Hong Kong, from my experience, our advice usually is you only challenge an award or attempt to set it aside if there really is a reason for it to actually be filed. One main factor of the Hong Kong courts is it's very rare that an award has been set aside or a challenge has been successful. I mean, this summer, one award was successfully set aside, that set aside was also rejected, and it was a huge deal in respect to whether or not a precondition was a matter of jurisdiction or admissibility. But I think I'm going far away from your main question. My clients usually don't try to set aside or challenge an award unless there is a likelihood of them to succeed. I will say
your clients don't lose; they always prevail. So that's right.
And it did. I have to say that I have had the benefit. We haven't really been put in a position yet, but knock on wood, I'm sure it will happen. I have seen a number of firms, solicitor firms, that have attempted to set aside the awards. It really depends on your client. In particular, mainland Chinese clients are quite adamant about the principle. So if they lose, they will try.
Okay.
Very big generalization.
Thank you. Thank you. Now, can I invite Blanca to offer some comments, and I would ask you the same questions, Blanca, if that's okay. I'm interested to know if there is a Latino change of perspective from what Sherlyn said.
Well, sorry if you hear strange sounds. We are under a thunderstorm, very hard thunderstorm here right now. As a matter of fact, Ecuadorian law does not mention the duty to disclose. We have the provision that the arbitrators must be impartial and independent from the beginning until the end of the proceeding, but that doesn't mean that you have an annulment ground based on the failure of the duty to disclose. On the other hand, we don't have any provision regarding public policy either way. Okay, any provision to have an annulment of the award, and also because of the grounds. So we don't have any judgment addressing the lack of disclosure or the public policy failure due to the lack of disclosure or the ethical. On the other hand, what we have is the duty of the parties to challenge the arbitrators if they feel the arbitrators are not as impartial and as independent as they must be. And also the duty from the arbitrators to reveal. But as I told you, it's just something that they must do because they need to do. We have on the rules from the arbitration centers that are working in the country some ethical procedures that makes the arbitrators obliged to disclose any situation that can be understood as a conflict of interest in them. And what happens if they don't do it is that they can be challenged, and if they are not challenged, the annulment proceeding is not going to amend that situation, okay? That's something to consider. But right now, there's a very strong movement within the arbitration community to adopt the disclosure of any conflict of interest and to excuse from the tribunal if that disclosure is understood as very important.
Okay, and would you like to add as well what would be the major reasons for setting aside awards? And you're based in Ecuador, right?
Yes, as a matter of fact, I am. Well, the grounds for setting aside are the ones of due process, not being notified with the arbitration, or not having acted an evidence that is very important, or not being notified with a hearing. Generally, not having the time or not having been afforded a due process during the arbitration. The most common ground in my experience is not one of those, is the extra petita, when the award from the tribunal is extra petita. So it is not too related to the due process, is related rather to the grounds of the award, because if you have to examine if the award is extra petita, you must see what are the grounds for the award, not just the process of it.
Thank you. Thank you, Blanca. Can we perhaps now turn to Stephen? Stephen, we have learned from Sherling that Americans' ethical compunctions are not as pronounced as those in Asia. That's an interesting fact, which I think you may want to comment. But in addition to that, I would ask you, what is the most common ground for setting aside, and how would an ethical a violation to an ethical code amount to cause of action to set aside an award, or no? Just it would depend.
Well, Ally McBeal and other television programs aside, I assume you used the term fact in quotes. I think we would like to think that here ethical considerations are extremely important, and most attorneys are, most arbitrators are attorneys, so therefore most arbitrators are bound by the ethical rules of at least one state bar, if not multiple. Now, the practice of arbitration is not the practice of law, and there may be circumstances that arise in an arbitration where the ethics are not covered by those that apply to lawyers. But by and large, I think that the arbitration community is very ethical because it is somewhat self-policing. None of us want to be the subject of a set-aside. Someone else said that earlier. I think Anne said earlier, don't want your name associated with a vacatur proceeding. And we all talk within the community, so we all know about it, and it's harmful to our careers as well. So there is a good deal of pressure. Also, one can be removed from a panel. In the United States, I think everyone knows the American Arbitration Association and JAMS make up together the lion's share of all arbitration, meaningful commercial arbitration anyway. And you can be removed from the panel for a non-disclosure. So there's plenty of motivation. Now that's not the only lack of ethics, of course, but it's a major one. It's a common one. Because we are called upon to make the judgment, do I need to disclose this or not? And when you train, you always say, err on the side of making the disclosure, and that is, of course, the best advice. So as far as what are the most common, one thing that most people probably know is that the United States is a little bit more complex because we have both federal and state systems. And there haven't been an awful lot of studies done, statistical studies, So much of what I'll say is anecdotal, although I have read one study done about 15 years ago. And based upon that, I will say that the arbitrator exceeded their powers is the #1 basis for a vacatur proceeding. And surprisingly to me, the statistic they gave was 21% are successful. So it's the most commonly brought and has the highest success rate. The second most commonly brought is manifest disregard of the law. Now, we think of that as, I've got nothing else to try, so let me try that. In our vernacular, we would call that a Hail Mary strategy. And not unsurprisingly, no, I'm sorry, not surprisingly, that only has a 4% success rate according to the study I read. But that's the second most commonly raised. The third most commonly raised is the misbehavior by which the rights of a party have been prejudiced. And that particular language comes right out of the Federal Arbitration Act statute on vacatur. That is the third most commonly raised, but the second most successful at 17%. And that category includes some peripheral things like the award is irrational, it was arbitrary and capricious, and it constitutes a violation of public policy. That's kind of lumped into that category. When you want to bring those types of claims, and the FAA, the Federal Arbitration Act, is your statutory basis, it would be that particular subsection that you raise them under. The fourth most commonly raised claim is arbitrators refuse to postpone despite a showing of good cause. And that is more or less a similar success rate to the previous one, 17%. And that's a warning to arbitrators. If somebody comes to you, you're not a court. You don't get to be as imperial as a judge in saying, no, you're going to be here, or I'm going to rule without you here. That should rarely be done in arbitration. And this success rate reflects that the courts don't like it when an arbitrator acts in that way. And the fifth category that the study spoke about is evident partiality and corruption. Not very commonly raised at all, and a low success rate of 12%. Because I think the failure to disclose claims are typically, again, also raised when there's not much else. Courts don't like it when they're raised late, when a party knew it and held on to it until after the award. A lot of the rule sets that are commonly used actually address that by saying it's deemed waived if you don't raise it in a timely manner. So that's kind of the lowdown of what we see here. If you have a moment, I came up with a few questions relating to, because public policy was a big topic for us today. I came up with a few questions that I thought might be interesting just to toss out there. Whether or not a state adopts public policy as a ground for vacatur kind of comes down to whether the state is willing to allow the parties to choose their process and then be bound by the result of that process, or whether the state wants to have control of the outcome. In other words, they'll override the process in order to decide what the outcome should be in appropriate circumstances. So my next question is, well, what is the state's interest in the correct outcome in a private commercial dispute? Does the state really have any interest in that? Because the parties have chosen the process they want, presumably chosen the arbitrators they want, or chosen a mechanism for selecting the arbitrator they want? Does the state's interest in it, is the state's interest in it more powerful than allowing the parties to have what they asked for? And so the next question is, that's kind of a laissez-faire sort of approach. If you're going to let the parties have what they asked, what they bargained for, that's very laissez-faire. And the question is there a cultural aspect to this kind of laissez-faire thinking? Would you see it in some places more than others because that's cultural? Next question is, to what extent does the degree of mistrust of non-judicial dispute resolution affect a state's position on this topic? It used to be very fair to say in the United States up to a certain point that there was a lot of judicial hostility toward arbitration. You could say the same thing in the United Kingdom for that matter. And I'm talking about the 1800s into the early 1900s. When arbitration became more institutionalized in the US in the 1920s and 30s, whenever it was that the AAA was founded, the courts began to soften their view about it and become a little bit more open-minded toward it. And so the mistrust has lessened, although in certain states, it's still very high. California in particular, in my personal opinion, is particularly anti-arbitration. But there's also the consensus building about arbitration of consumer disputes or pre-dispute arbitration agreements that was enacted in the European Union and is really becoming a battleground here in the States. And my last question is, do parties have the right to select a dispute resolver who might get it wrong? Do they have the right to pick someone who might get it wrong? And if so, if not, why not? What's the policy that should prevent that? Those are just some questions that I thought I would leave people with on that topic.
Okay.
Have I left you speechless with that?
I wasn't expecting that. Okay, so Andrea, make sure we speak before having Stephen again.
There you go.
Yeah, absolutely. Yeah, you bring some really interesting thoughts. I know Paula is. Do you want to comment on something, Paula, or did I get it wrong?
I would like to make a suggestion. Could we have another panel tomorrow trying to answer those questions, all those questions?
And talk about the questions. I'd love it.
We could talk about these questions.
We need to invite Stephen again from our group to speak a little bit more, Professor Paula. We see you together.
Well, who knows where that will go.
Thank you. Our last speaker would be Ricardo. So Ricardo, as we are very good friends, can I put you on the spot and ask you to provide us with some very, very witty comments on Stephen's points, and then, of course, I think we would welcome your view on how a violation to an ethical duty might lead to the annulment of a arbitral award, if it would, and at all. And I understand also you have some comments on the common grounds for setting aside. So we'll let you have the grand finale, and please don't ask any questions. So don't follow up on Steve's behavior.
Okay. Well, I imagine that you would put me in the spot even without warning before. So
right.
in a way, I thought I was invited for that
For that
reason.
specific purpose, yes. Yeah.
Well, anyway, it's a great pleasure and honor to be here with you all, to know you all and let you know something about myself. And other than being Tonico's friend, I will try to explain some things from the Brazilian perspective, or from the Brazilian point of view. First, we have, I think, a first comment that occurs to me is that I'm very happy because we have basically the same issues. There are some coincidence in what we are facing in our arbitration practice and things that you all said. So we are not developing a different approach. We are not suffering different things or facing different challenges. It changes a little bit, but anyway, we are not from Mars. I'm happy as a Brazilian to say that we are pretty much like yourselves. But we have in our Brazilian Arbitration Act something different, because there is a specific provision saying that anyone, any person, a capable person can be an arbitrator if it has the trust of the parties. So we put in our legal system the legal concept of trust. And this might give us some problems, some trouble, because we are facing in some cases the discussion of what is the extent of that trust. Because when you, and specifically when you have a concern or an issue about the something that was not disclosed, properly disclosed, the consequence is, since you have not disclosed, I lost my confidence in you. I lost the trust that I had in you, Mr. Arbitrator. So this is a ground to setting aside. Our law doesn't say that, but it's a bridge that we cannot build this bridge, but this is a concern that I would say, and we have here and there a few courts decisions trying to make that bridge. So without doubt, the duty to disclose it's a legal standard in our system, but it's not a ground to set aside an award. So one thing does not bring to the other automatically. Tonico, to answer properly, what are the ethical standards, and if there are grounds for that in our legal system? Our colleagues might not know, but you know the answer. Andrea knows the answer. So if I lie too much, you will know, and you will let them know.
You set aside your word.
Yes. Other than that, we have our policewoman here. Everything we do, Andrea is looking, and we have to be very. We have to pay to pay attention on that. But anyway, from a legal point of view in Brazil, the ethical standards they will lead us to the impartiality and to independence aspects of the activity of the arbitration. We have in our legal system these two standards: independence and impartiality. So this is the path to set aside an award here. The lack of independence and impartiality, if it's due to an ethical misconduct or the violation of the duty to disclose, this is the path that you might set aside an award here in Brazil. And as Sherlyn said, and some of you colleagues, I think here we have maybe and an increasing culture behavior that if I lose, I will try to set aside. This is something that it's coming more and more common in our practice. No questions asked, Tonico.
Okay, but I'm sure Stephen would like to say something, don't you, Stephen? No.
I'm happy to add to that I think the likelihood of a challenge to an award is directly proportionate to the size of the case.
Mm-hmm.
That
Okay,
sounds very accurate.
a final question for everyone. I know you're very experienced arbitrators, and I wonder, have you ever regretted making a disclosure in a case?
Not at all.
Dorothy put up the
Not
idea
at all.
that in case of doubt, one should disclose.
Yeah.
Would you agree with that, Stephen?
In case of doubt, disclose? Absolutely.
Yeah.
Yeah, absolutely. I've disclosed some very obscure things and been tossed off cases, not off cases, but disqualified at the inception for some very obscure things, like the claimant was a sister entity with a common parent to the company that provided my wife's healthcare insurance.
Wow. Okay.
At a time when it didn't provide mine. So yeah, but I disclosed that, and okay, err on the side of disclosure.
Tonico, oh, sorry, Dorothy.
No, I said absolutely. Err on the side of disclosure.
Sometimes I think that by disclosing this, let's take Stephen's example. If you look to any guideline, this situation will not be there. So probably any legal system will not put the standard that high. But it's good to disclose anyway. But sometimes when I'm facing a situation like Stephen's, I think to myself, I might be helping to put the bar higher and higher, because we are basically disclosing everything. So where is the end? What will be the end of the duty to disclose?
I would love to toss out there that my supplemental disclosure, which for AAA and ICDR, you do an initial disclosure online, and then if you have anything else to add, you upload a supplemental disclosure. Mine is 4 pages, single spaced. And that's because it's largely because of my activities or social media, things that I say. I don't know everybody that is linked to me on LinkedIn. I don't ask for people to make recommendations, and I can't vouch for the accuracy of those recommendations. I've written articles, I don't know who's read them. I've presented and I don't know who's been there. I'm a teacher and I don't know who else teaches at the school or who my students may have been in the past, et cetera, because these are kind of like having fourth cousins. They're so far out there that you think that they're irrelevant, but I even amend it from time to time to add something new when I read something in someone else's. I just put it all in there, and basically it's, don't say I didn't tell you.
I have a question for both of you. In Brazil, we have a weird drafting law ongoing addressing that arbitrator should disclose how many hats or how many cases, similar cases they have before accept any appointment. How does it work in your country? Because here, arbitral community is very concerned about this drafting law, because it's not for legislature or judiciary decides, but maybe agency, ABR, AAA, ICDR regulate these issues. How Stephen, does it work in US, this issue?
That's a statute in Brazil? A law?
It's not statutory yet, but it's a draft. It's a draft.
A draft. Okay. Well,
a draft.
The thing is, in the United States, I'm fairly sure California requires reporting of that, but not disclosure every time you're appointed. I have not had a case where I had to travel to California. I've had California parties who come to New York where this law doesn't apply. If I got asked to serve on a case in California, I would have to give it very serious thought, because they require you to get a temporary admission to the bar, to pay a bar membership fee, and to do this disclosure. I don't know the exact particulars of it. I think it's more or less like that, but that's only California. I've never heard it in any other state. There's certainly no federal requirement. I don't like the idea at all, most particularly because if you're a young arbitrator and haven't had, if you can go in there and say, I've had 300 arbitrations, that's fine for getting selected by significant parties. But if you're on your 7th arbitration, there may be a lot of people who are not going to pick you. It's going to make it very hard to progress. I mean, there is an element of truthfulness and being forthcoming about saying I'm a relative newcomer, but I think that there's other ways for that to be gleaned from the CV of such a person. And it doesn't require what is essentially a little bit of an embarrassing detail in the context to be made public in that way.
I agree with you.
I just asked for a quick clarification on the draft. Is it a disclosure of how many cases you're currently sitting on, or your experience, or both?
They ask for or limited number of the hats or cases the arbitrator should accept, and you have to disclose that for the parties also.
Okay, because I mean, in Hong Kong, there's not that requirement, but the ICC in its statement of acceptance and availability, they do ask for the number of cases that you are currently sitting and that you have sat, for purposes of making sure, and it's not really to test whether or not the arbitrator has the experience, it's to test whether or not the arbitrator has the time to properly devote to.
Or maybe conflict or not, to check conflict also, or just to make sure about the time.
I think it's availability.
It's the time.
I think it's about availability, more on
I don't like that as an approach, because I had 3 cases settle in a matter of 2 weeks, and then another 2 go to award within 2 months of that. So, my caseload goes up and down, and I kind of know where the sweet spot is. I don't need the ICC to say, well, you're at a peak now, so we won't give you anything else, when I know that 2 cases are going to award, and statistically half of the rest of them are going to settle. It doesn't really.
Aren't you requested to provide your schedule as to when you have dates available for a hearing? I think the ICC does that, doesn't it?
It does. And I mean, this is also because I'm biased, because I used to work with the ICC, but we often saw, and from a counsel perspective, we see a lot of arbitrators, they're not all like you, Steve. We have a number of very high profile arbitrators that tend to take all the cases. And that's actually why the ICC implemented the statement of availability, because we started seeing arbitrators who had over 40 arbitration matters. And I do understand that certain things will settle, so on and so on. If you've got 40 ongoing cases as an arbitrator, it's hard to imagine how you're going to be able to take on another one.
That's a crazy docket. I agree with you. 40, that's crazy, but.
And some arbitrators have a team that's larger than some law firms.
Yeah.
So,
and some people are sitting for 6 months of hearings on a case, and they could have 3 cases, but they don't have room for a 4th.
So it's an interesting draft. I'm surprised to hear that it is being considered for actual statutory. For usually it's something that
I think it will be a nightmare, because when this issue goes to the legislature, it's not good, because they will how can I say, attached or decide something is not their business. So I think it's very dangerous for arbitration in Brazil. Make this kind of drafting. I think it will be more useful that arbitral institutions decide about that, or organizations such as CIR or CDR, or even the Brazilian Bar Association decide this issue or regulate these issues, because when these issues goes to the court or legislature, it's not good.
I don't think there's a chance of. I don't think this bill will pass. There's strong opposition from most of the institutions, and Brazil actually says it was in Congress lobbying against this bill, which also limits the number of arbitrations that each arbitrator is allowed to take. So somebody came up with a magic number of 10 arbitrations, and obviously somebody has complained. Somebody's attacking the mafia, so to speak. We all know that the country club is a strong concept, and I think every country. So this is how we see this bill. But honestly, the opposition has been so strong that I very much doubt that this Congresswoman will put it forward.
It's a revenue sharing measure.
Yeah.
Please, Tonico, closing remarks.
My closing remarks is just a gigantic thank you for everyone. Paula, Dorothy, thank you very much for staying up so long. I know it's going to be a red eye webinar, but thank you for your generosity, and Shelling as well. You've been amazing. Stephen, just thank you. Ricardo and Blanca, also thank you guys very much, and look forward to seeing you soon. Stephen, you're amazing. You're a star. We love you.
Thank you very much. I'll go home and tell my wife.
Good point. Thank you very much.
Thank you. Thank you.
Thank you.
Thank you all very much.
Thank you.
Bye, guys. Thank you very much.
Bye-bye. Good night.
Great to see you.